Jeffries and I'm a special tax consultant with WTS Australia. The government has introduced some draft amendments to Part 4A, which is the general anti-avoidance provision of the Australian income tax law. These changes to Part 4A were announced back in March 2012, but they will apply from the 16th of November 2012. Now, they are draft amendments and they still have to go through the parliamentary process, but they have now been introduced and they are effective as of now. Let me just give you a brief rundown on what Part 4A does. Part 4A is the general anti-avoidance provision of the income tax law. We have other anti-avoidance provisions, but this is the general one. There are 4 parts to a Part 4A application. First of all, there has to be a scheme, then there has to be a tax benefit. Then that tax benefit must have been achieved with the sole or dominant purpose of achieving that tax benefit. And lastly, the Commissioner has to decide to apply Part 4A. That structure has not changed under these proposed provisions. Well, in recent years, the Tax Office has lost some Part 4A cases over this concept of a tax benefit. So what's happened is that the courts have focused on this question of a tax benefit, which requires a comparison between what actually happened and what is proposed to have happened under what is known as an alternative postulate. Now, because the Tax Office have come to the view that Part 4A is being focused on this tax benefit issue rather than the purpose of the tax avoidance or the purpose of the tax avoidance part of the scheme, they wanted to shift the law back onto emphasising the purpose of tax avoidance rather than just this focus that has been on the tax benefit. So that now there will be what is known as a single holistic approach to the application of Part 4A. The thrust of the changes are in a new section 177CB. This requires the Tax Office and taxpayers to make certain key assumptions about the alternative postulate. These assumptions are that, first of all, that a person would have acted without regard to the tax liabilities of any person. Secondly, the non-tax effects of the actual events must also be replicated or available, if you like, in the alternative postulate. So, the alternative postulate by which the tax benefit is measured must have the assumption that the non-tax effects are the same as under the actual events, and also that people would have acted without regard to anyone's tax liability. Now, these two assumptions are 2 levels of unreality, but yet this law is proposed to apply right now, and with these 2 levels of assumptions, it seems to me that it will be inevitable that there will be confusion as to what these changes mean, and the outcome of it will be, I have no doubt, that people will be seeking even more private rulings from the Tax Office on what Part 4A means. So what are the implications of these new changes? Well, first of all, it seems possible that people are going to be assessed on transactions that never occurred and also would never have occurred, because you have to assume that people will act in ways that will ignore their tax liability, and people just don't do that. Secondly, the provisions introduce this concept of the non-tax effect. Now, for the tax office to apply Part 4A in their alternative postulate, they must be able to identify all of the non-tax effects that were there in the actual events. And so if they can't do that, then they can't apply Part 4A. And so there is an assumption that the tax office can readily determine what the non-tax effects are and replicate them in the alternative postulate. One wonders whether this is going to create problems for the tax office. And as I said before, I've got no doubt that the tax office is going to get a lot more requests for private rulings in relation to the operation of Part 4A. And remember that those ruling requests have to give all of the details that are necessary for the tax office to make that decision. And so we're going to have lengthy ruling requests to perhaps an overloaded tax office.